You're welcome to my channel. In this video we are going to be looking at the duties of directors. In our previous video we first introduced the board of directors and we talked about who a director is. We said a director is any person occupying the position of a director by whatever name called, and this is according to section 2 of the Companies Act. So in this video we are going to be looking at the duties of the directors, and this is provided in section 198 of the Companies Act. The director has mainly two duties. The first duty is the duty of care and skill, and then the second duty is the duty of good faith. So we are going to look at each one of them in details. Let's start with the duty of skill and care. We said a director has a duty of skill and care. There is no criteria for measuring the standard for acting with skill and care. As such, this would depend on the circumstances of each case. Nevertheless, courts have tried to set some guidelines to what amounts to skill and care. Like, a director has to act with skill and care when he's doing his work, but there is no criteria for measuring the standard for acting with skill and care. It would just depend on the circumstances of each case. And this was seen in the case of City Equitable Fire Insurance Company Limited in 1925, Chancery Division 407, where a court held that directors were liable for breach of the duty of skill and care on the grounds that they were negligent. So directors are not supposed to be negligent when they're doing the company work. They are supposed to act with skill and care. The second duty of directors is the duty to act in good faith. Good faith, it's like being trustworthy. The directors stand in a fiduciary position to the company, like they owe the company some duties. A fiduciary relationship is when there is always a party that has an upper hand in the relationship, e.g. the lawyer to client relationship. The lawyer has an upper hand in the relationship. Then the doctor to patient relationship, the doctor has an upper hand in the relationship. So the party that has an upper hand in the relationship is supposed to act in good faith. And any cheating by this party will be punished in the courts of law. The duty of good faith is subdivided into 5 components. And the first one is the duty to exercise the director's power with good faith and for proper purposes. Like, if you have powers of being a director, you have powers of a director in a company, you are supposed to use those powers for good purposes, for proper purposes. And this was seen in the case of Percival versus Wright in 1902, Chancery Division 421, where a court held that the principle of the duty of good faith is owed to the company and not to the individual shareholders. So the directors owe the duty of good faith, the duty to act in good faith to the company. And they're supposed to use the director's powers with good faith and for proper purposes. The second component of the duty to act in good faith we have when dealing with the company's property. The duty of good faith requires that a director should take care to protect the company's property. And this was seen in the case of George Newman and Company, where a court held that the company's assets are its properties are not for the shareholders. And if directors misapply such assets, they will be held liable for misapplication. So they are supposed to take care to protect the company's property, or else they will be held liable for misapplication of the company's property. Another component of the duty to act in good faith is making secret profit out of the company. Directors should avoid making secret profits at the expense of the company. However, Section 200 of the Companies Act and Article 84 of Table A modify the rule to allow a director to make a profit out of the transaction, provided he has disclosed his interest to the board. Like, a director can be able to make profit out of the transaction as long as he lets people know about it. Like, he lets the board know about it. Yeah, but otherwise, he's not allowed to make a secret profit out of the company. The fourth component of the duty to act in good faith is prohibition of insider trading or trading in securities of the company. This is where a well-positioned officer in the company uses sensitive and important information about the company to his benefit. Yeah, instead of selling the company's things, he sells his own products. That's what we call insider trading. He uses sensitive and important information about the company to his benefit. And the last component of the duty to act in good faith is the duty to declare conflicting interests with the company. Section 128 of the Companies Act states that a director with any direct or indirect interest in a contract with a company must declare the nature of his interests in a meeting of directors so that the company can know. Yeah, a director has a duty to declare conflicting interests with a company. And that was all about the duties of directors. We say directors have two duties. The first duty is the duty to act with skill and care. And then the second duty is the duty to act in good faith, which is divided into 5 components. Yeah, and the first one was the duty to exercise the powers for proper purposes. Then the duty to take care of the company's property, the duty to declare conflicting interests with the company, the duty not to make secret profit out of the company, and lastly, prohibition of insider trading. Yeah, thanks for watching. Don't forget to subscribe, like, comment, share with your friends, and watch my next video. We shall be talking about other officers and their duties of the company.